there was a firefight between the victims and the officers in the police station Leyte sub-provincial jail. Nor is there a need to enter into these conflicting accounts because the prosecution's own evidence exculpates Rodrigo Duterte for responsibility for this incident. Not that he admits any connection to it. After all, according to the prosecution, on 1 August 2016, Rodrigo Duterte gave Espinosa a 24-hour ultimatum to surrender. And surrender he did the following day. 4 days later, Rodrigo Duterte commended Espinosa for surrendering to Ronald de la Rosa, commenting that it was just as well that he did. So if we look at it from the point of view of Rodrigo Duterte, that is where the incident ended.
Sumentro ang huling argumento nitong si Kaufman sa tatlong krimen na iniaakusa laban sa dating Pangulong Rodrigo Duterte. Ang una rito, Bombo Dennis, ay yung murder as crime against humanity na nangyari sa may Davao City nung siya ay alkalde pa lang naturang lungsod. Umabot sa 19 na biktima ang sinasabing natukoy dito na sinasabing nangyari sa pagitan ng 2013 at June 2016 o bago sa tuluyang nanumpa bilang Pangulo ng Pilipinas. Ang pangalawa ay ang murder as crime against humanity sa mga high-value target sa iba't ibang lokasyon sa buong Pilipinas sa ilalim pa rin yan ng kanyang pamumuno bilang Pangulo ng Bansa. Umabot sa 14 na biktimang natukoy dito sa pagitan ng July 2016 at July 2017. Ang ikatlong kaso ay ang murder and attempted murder sa crimes against humanity sa mga isinagawang barangay clearance operation sa iba't ibang lokasyon sa buong Pilipinas bilang Pangulo na ito ng Bansa. Ayon kay Attorney Kaufman, sa lahat ng mga kasong ito, walaan niyang maipakita ang panel ng prosecution na anumang koneksyon kay dating Pangulong Rodrigo Duterte na siya ang nagbigay ng kautusan para isagawa ang mga operasyon sa ilalim pa rin ng command ni dating Philippine National Police Chief General Ronald Bato de la Rosa. Balikan natin yung bahagi pa ng mga pahayag na Attorney Kaufman.
There's no evidence on the perpetrators, victims, motives, manner of attacks, methodology, in essence, nothing to link them to an alleged fantasy common plan. Everything is just stitched together enough to give it a veneer of organization. I now turn to incidents reflecting documented armed confrontations. And as mentioned when I first turned to this count, the documentary record, which has not been displaced by any evidence proffered by the prosecution, reflects attempted arrests, resistance, and responsive use of force. And you've just seen some of the documents up there on the screen. Let's turn briefly to Incident 17, for which the prosecution has relied on a witness who stated that the planting of evidence was an open secret in the locality and province more generally. However, another witness, working in the same locality, P1208, states otherwise, that he was never involved in illegal operations resulting in deaths, was not aware of extrajudicial killings disguised as lawful operations, and confirms that there were no standing orders to kill.
Kinwestiyon din ni Attorney Kaufman ang pagbibigay diin ng prosecution panel na maraming mga bata o mga menor de edad ang nasawi sa kasagsagan ng drug war. Gayunpaman, tanging si Kian de los Santos lamang anya ang kanilang nagawang ipakita o idokumento o kung hindi man iharap sa tribunal sa kabuuan ng pagdinig. Wala niyang naipakita ang prosecution panel na anumang corroborative evidence tulad ng birth at death certificate sa kanilang claims na maraming minor ang napatay. Sa kabuuan, nanindigan si Kaufman na hindi nagawa ng prosecution na mag-establish ng anumang link sa pagitan ng malawakang patayan at ng kanyang kliyente itong si dating Pangulong Rodrigo Roa Duterte. Sa naging closing remarks naman ni Attorney Edward Jeremy, ang kinatawan ng prosecution panel, binalikan niya ang maraming pagkakamali nitong si Nicholas Kaufman sa maraming pagkakataon. Kabilang dito niya ang pagsasabi ni Kaufman na walang common plan dahil walang ma-establish na connection sa mga patayan at ni Pangulong Rodrigo Duterte bilang principal suspect. Ayon kay Attorney Jeremy, marami ang na-establish ng prosecution tulad ng circular memorandum na inilabas ng Philippine National Police at record ng mga napatay bawat napatay na individual. Hindi rin anya nakakalito ang terminolohiyang neutralize, hindi tulad ng ipinipilit ni Kaufman at ng defense panel. Binalikan na Attorney Jeremy ang ilang police record kung saan nakasaad na ang mga taong dating napabilang sa drugs watch list ni dating Pangulong Duterte ay namarkahan sa ibang record bilang neutralize. Ibig sabihin, ito'y patunay na ang tunay na kahulugan ng neutralize ay patayin. Balikan natin yung bahagi ng paliwanag ni Attorney Jeremy.
Okay, what do we see there? This is essentially Mr. Duterte's farewell speech. It was made on 9 March last year, 3 days before, as he says, he was apprehended. He was not going to surrender, apprehended and surrendered to The Hague. What did we see there? First, I won't repeat it, shows total, utter contempt for this court. Second, referring to, quote, his sin, end quote. He says, assuming that all the talk you hear is true, assuming it's all true, why did I do that? What is the talk that's all true? It's obvious. After he says that, he says, problem is, they think I'm the one who, and the crowd cheers. Again, he doesn't say it out loud because he knows he's on video. He doesn't want the words there. Assuming I'm the one who killed all these people. So he makes a little motion. Crowd goes wild, and he smiles because he likes that after he's made that statement. What innocent person has ever said, assuming I committed all these murders, it was for a really good reason? That's what they would like you to believe, that he doesn't mean it. And he says he did it not for himself, not for his family.
Pahayag nitong si Attorney Jeremy ng prosecution panel. Samantala, inisa-isa naman ni Attorney Gilbert Andres ang mga puntong inilabas ng Defense Counsel na si Attorney Kaufman na anya'y pawang mga kamalian o pagkakamali. Naghanda si Attorney Andres na nagsisilbing common legal representative for victims ng hanggang sa 10 rebuttal sa mga punto o laban sa mga punto at argumento ng defense panel, lalo na itong si Attorney Nicholas Kaufman. Kabilang dito ang anyay maling konteksto na ibinibigay ni Kaufman sa pagiging pangulo ni dating Pangulong Duterte at ang kanyang command sa public attention dito sa Pilipinas. Dito ay inihalimbawa ni Kaufman ang political at cultural context kapag ka ikaw ay Pangulo ng Pilipinas at nagbibigay ka ng command lalo na sa mga law enforcement agencies dito sa ating bansa. Inalala rin ni Attorney Andres ang ilang mga desisyon ng International Criminal Court Pre-Trial Chamber 1 sa ilang mga nagsisilbing mga president na mali ang pagkakagamit daw batay sa naging presentasyon nitong defense panel. Balikan natin yung huling yugto ng naging mensahe kanina o presentasyon kanina, submission kanina ni Attorney Andres bago natapos yung kanyang mahabang mensahe.
Also, we want to emphasize, Your Honors, that there were indeed children murdered systematically under the charges that are being held against Mr. Duterte, Your Honor. And they are not mere collateral damage. In conclusion, the victims submit that the defense has not blemished the prosecution legal theory and evidence as provided in the document containing the charges and the pre-confirmation brief. The victims submit that the prosecution presented sufficient evidence to establish substantial grounds to believe that Mr. Rodrigo Roa Duterte committed each of the crimes charged. Consequently, all charges should be confirmed and Mr. Rodrigo Roa Duterte committed to trial.
Yeah. Bahagi naman yan ng naging pahayag ni Attorney Andres, ang isa sa mga accredited lawyer, Filipino accredited lawyer ng International Criminal Court, Bombo Dennis. Bago tayo magtapos, balikan lamang natin dahil hindi rin pinalagpas ang International Criminal Court Pre-Trial Chamber 1 yung paulit-ulit na ginawa ng lead defense counsel na halos paglalantad dun sa pagkakakilanlan ng mga testigo at mga biktima ng drug war. Dahil nga rito, pinaalalahanan ni Presiding Judge Yulia Antonella Motok si Attorney Nicholas Kaufman sa kalagitnaan ng pagdinig na irespeto ang desisyon ng International Criminal Court Chamber 1 tungkol sa reduction para protektahan ang pagkakakilanlan, seguridad ng mga biktima at ng mga testigo. Ginawa ang mga redacted information anya upang maitago ang tunay na pagkakakilanlan ng mga testigo at mga biktima bilang proteksyon sa kanilang seguridad at sa kanilang kaligtasan. Kahapon, kung babalikan natin, ilang beses na natigil ang live stream at yan ay matapos ngang ilabas nitong si Attorney Kaufman ang ilang impormasyon na ayon sa International Criminal Court ay posibleng maaring makatukoy sa pagkakakilanlan ng mga biktima at ng mga testigo sa kaso laban kay dating Pangulong Duterte. Muli din itong naulit ngayong araw dahilan upang tuluyang i-catch nitong si Attorney o nitong si Judge Mutok ang attention nitong si Attorney Kaufman sa kalagitnaan ng pagdinig. So hinihintay pa rin natin bubudanin yung huling bahagi o huling session ngayong day 4 ng confirmation of charges hearing ni dating Pangulong Rodrigo Duterte. Yan muna ang ating update. Back to you, Bombo Dennis.
Yan, maraming salamat Bombo Genesis at mga kabombo, mga Kastar Nation. Tayo'y nakaantabay na dito ho sa resumption at nasa final hour stretch ang confirmation of charges hearing. Oras natin mga kabombo ay 30 minuto makalipas ang ikasyam ng gabi. So maliban ho dyan sa confirmation of charges ay inaantabayanan din natin kung may tagubilin ang mga huwes na humahawak ho dito kagaya nung kanilang tagubilin sa panig ho ng depensa doon sa mga pagkakataon na nagkakaroon ng paglalantad sa masiselang impormasyon ukol pa rin sa naturang kaso. So, ganun din. Yung mga schedule, kung kailan ang nakatakda ng mga susunod na schedule at kung mapapabilis ba ang paglalabas ng desisyon ukol ho dito sa kahilingan ng kampo ni former President Rodrigo Duterte ukol sa kanyang detention at yung interim release issue na hindi pa rin natutuldukan dahil may inilalatag na rason. Yun hong kampo ng depensa. Kasama na ho dyan yung aspetong pangkalusugan ni former President Duterte, pati na ho yung kanyang pagiging makakalimutin na umano sa mga bagay-bagay at detalye kaya hindi na niya maalala, hindi magiging madali sa kanya pag sumalang sa full trial dahil sa kanyang kalagayan bilang isang tumatanda na at nakakalimutan na rin ang iba pang mga impormasyon sa maikling panahon mga kabombo at mga Kastar Nation. At maliban ho dyan ay inaantabayanan din ho natin mga kabombo kung may ibibigay pa na pagkakataon sa magkabilang panig kung ilang saglit maaaring makapagsalita itong dalawang kampo. Kasi the moment na binibigyan ho sila ng tsansa ay talagang sinusulit. Kagaya ho nitong si Edward Jeremy ay talagang hinimay niya at kumbaga parang dito rin sa atin. Pagka meron ho siyang nilalahad na aspeto o kaya naman ay argumento at pagkontra doon sa kabilang panig ay naglalabas pa siya ng kanyang mga katibayan and may mga punto na nag-play siya ng mga old clips ni former President Rodrigo Duterte para patunayan yung kanyang pinupoint out mula ho doon sa mga huwes na humaharap dyan sa International Criminal Court. Pansin nyo mga kabombo, mga Kastar Nation, yung isa sa video na ipinalabas, ito yung event dun ho sa Hong Kong. Yan yung ilang araw bago siya bumalik dito sa Pilipinas and aon nga ng Marso nang maaresto ang dating Pangulo dyan sa bahagi po ng Ninoy Aquino International Airport and then itinuloy doon sa Villamor Air Base at mula dyan sa Villamor Air Base ay inilipad naman patungo na ng Netherlands. At hanggang ngayon ay nananatili ho ang dating presidente ng Pilipinas dyan sa detention facility ng International Criminal Court at yan ay alinsunod doon sa in-issue na warrant of arrest ng International Criminal Court. Tingnan nyo mga kabombo, magkaiba no, ang korte na karaniwan ho nating natutunghayan dito sa Pilipinas at yung International Criminal Court. Ito kasi sa puntong ito, hindi pa ho nakakapaglabas ng plea ang dating Pangulo ukol sa mga inaakusa laban ho sa kanya. In fact, hindi pa ho siya tinatawag na accused as of this moment, kundi isang suspect. Suspect pa ang turing kay former President Rodrigo Duterte at itinuturing pa siyang inosente maliban na kung mapatunayan yung mga inaakusa po sa kanya mga kabombo. So ganun, no? Pero ng warrant of arrest, naisilbi na ito at naaresto na yung tao kahit hindi pa ho nababasahan ng sakdal at ngayon ho, yan yung confirmation of charges hearing pa lamang. Nandito pa lang sa level ho na ito. Pero yung personalidad ay hawak na ho nila. In fact, mag-anibersaryo na ho ito ngayong paparating na buwan ng Marso. 11 ho siya nang naaresto dito ho sa Pilipinas, mga kabombo. So, totally magkaiba ang takbo ng mga patuparin at mga lituntunin ng International Criminal Court at ng local courts dito sa ating bansa. Kaya nga may mga nagbabanggit, dapat ideally, sabi nga ni Senator Bam Aquino, ideally dito dapat litisin yung mga personalidad na inaakusahan sa kahalintulad na issue. Bagay na kinukontra naman ho ng ilang mga grupo kahit maging nung kanyang mga kasamahan sa partido, mga kabombo. So ganun kasalimuot, nagbabanggaan yung ideya, aspetong legal, aspetong politika ay talaga ho, nagbabanggaan, nagkokontrahan ang magkabilang panig, mga kabombo at mga ka-Star Nation. So tayo nakatabay pa rin dito ho sa mga kaganapan sa International Criminal Court. Oras natin, meron na ho tayong natitirang 25 minuto bago ho sumapit ang alas 10 ng gabi at yan ay nakatabay pa rin tayo dyan sa International Criminal Court. Ahead ho tayo mga kabombo, kung di ako nagkakamali, nasa 7 oras ho ang ahead ang Pilipinas dyan sa the Netherlands at yan ho yung ating pagkakaiba. No? So sa kanila ho doon, kung dito ay gabi, sa kanila ho doon ay bandang hapon, mga kabombo at mga ka-Star Nation. And of course, yung kanina na tanong natin sa ating mga interviewees, yung magiging paraan kung paano ho yung full trial, sa paglalarawan ho kanina ni Attorney ni Justice Antonio Carpio, retired Supreme Court Justice, ay may mga proseso ho na pagdadaanan ho ito at hindi ito kalintulad ng mga iniisip ho natin ng mga pamamaraan. Ganun din ho yung mga paliwanag ng mga nagsulong ng reklamo kagaya ng mga pahayag kanina ni Attorney Cortez, mga kabombo, ng NUPL and pati na yung iba pa ho ng mga resource person natin dito sa ating tuloy-tuloy na mga updates na kinukuha at kinakalap mula pa ho kanina. And kanina, meron din hong mga update mula ho dyan sa UP Diliman sa Quezon City, mga kabombo at mga ka-Star Nation. Well, i-check natin maya-maya mga kabombo yung communication line ng ilan pa ho sa ating mga reporters kung meron pang mga karagdagang update dito sa mga kaganapan na tinututukan, lalo na't may hanggang gabi ito, viewing time, ibig sabihin hanggang sa mga oras una ito, naroon pa rin ho yung ilang mga grupo, mga kamag-anak ng mga nasawi sa War on Drugs campaign upang ituloy yung kanilang watch party o kung ano man ho yung tawag na termino ho nilang ginagamit sa sabay-sabay na pagtunghay ng mga kaganapan dyan ho sa International Criminal Court. Ang setup ho mga kabombo dun sa University of the Philippines ay nandyan yung mga kamag-anak ng mga biktima ng war on drugs. And then, meron hong in charge na abogado na every break time, ay meron hong magpapaliwanag kung anong naging takbo ng kaganapan para dun sa mga kababayan ho natin na hindi naman nagkaroon ng pagkakataon na roon ng background ng tungkol sa mga batas, at least may paliwanag in layman's term. Kaya nga, no? At sa tulong ho yan ng mga abogado na umaalalay ho sa kanila dyan sa University of the Philippines na kahit papaano ay mailahad ho sa kanila kung ano yung nagiging takbo ng usapan, at least guided pa rin ho yung ating mga kababayan dyan, mga kabombo at mga ka-Star Nation, na nakaantabay dun sa takbo ng kaganapan sa International Criminal Court. Maliban ho dyan mga kabombo, mga ka-Star Nation, naantabay ho tayo dun sa another 2 months, 60 days 2 months ho na hihintayin natin kung anong ilalabas na pasya ng pre-trial chamber 1. Imagine, nasa pre-trial pa lang ho tayo. Wala pa tayo sa trial proper o yung full trial. Pero ganito na kasalimot, ganito na katindi yung palitan ng mga argumento ng magkabilang panig. So, yan pa lamang mga kabombo, mga ka-Star Nation, yung ilan sa mga kabang-abang. And that's 60 days na hihintayin ho natin. And of course, may mga other development din siguro, mga filing ng kanilang mga additional information at mga requirements. Halimbawa, hihingin ng panig ho ng mga huwes. Yan ay nasa kamay ho ng panig ng prosekusyon at depensa para ipursigi yung kanilang argumento, mga kabombo. So, check muna tayo ng mga evening events dyan ho sa viewing ng mga kamag-anak ng mga biktima ng War on Drugs campaign. At nariyan sa linya pa rin si Bombo Isa Cotoner. Bombo Isa, please come in.
Yes, Bombo. Dennis, nagpapatuloy ang isinasagawang group watch o yung tinatawag ding Justice Watch ng Duterte Panagutin Network kasama ang mga kaanak ng mga biktima na extrajudicial killing sa panahon ng War on Drugs ng dating Pangulong Rodrigo Duterte. Sama-samang tinututukan ng grupo dito sa may University of the Philippines, Diliman, ang mga kaganapan sa pagdinig ng International Criminal Court, partikular ang mga pahayag ng kampo ng depensa. Sa gitna ng panonood, may mga abogado na nagpapaliwanag sa mga argumento ni Defense Counsel na si Nicholas Kaufman at pati na rin yung nagpapatuloy na proseso upang mas maunawaan ng mga pamilya ang takbo noong hearing nga at ang mga terminong legal na ginagamit sa pagdinig. Bukod sa legal na talakayan, ibinahagi rin ng ilang kaanak ang kanilang personal na karanasan at ang anilay aktwal na pangyayari sa pagkamatay ng kanilang mga kaanak. Pinabulaanan nila ang ilang pahayag ng depensa ni Attorney Nicholas Kaufman na nanlambad umano ang mga nasawi. Ayon sa kanila, walang katotohanan ng ganitong naratibo at iginiit na biktima ang kanilang mga kaanak. Nag-alay rin ng mga pamilya ng candle vigil para sa mga namatay na kamag-anak at patuloy na iginigiit ang katarungan para sa kanila.
Okay,
Samantala,
Bombo Isa.
Yes, Bombo, Dennis?
Oo. Bagamat napakaganda ng kwento mo sa mga oras na ito, hinggil dyan sa mga kaganapan sa University of the Philippines, Diliman, bibigyan daan muna natin, nag-resume na itong International Criminal Court para dito sa huling ilang minuto na lamang bago ang pagtatapos ng confirmation of charges. Pakinggan natin mga kabombo.
So he thought to kill emanating from Mr. Duterte, and that is to be found in Incident 1. So, for the benefit of the record, let me just clarify and repeat what I said, and I refer you to transcript 4, page 65, at line 14 onwards, and I quote, P26, who, redacted, claims that Mr. Duterte telephoned a redacted third party to order the operation and was told it was the mayor on the phone. Pure hearsay. That's what I said during the hearing. And I stand by my word. But because I thought that maybe Mr. Nichols might have caught me out, I went back to the transcript and the record, and I looked long and hard, and once again I quote P26's words from the evidence. I asked who called, and the redacted third party said, Superman. And to make things clear, the prosecutor's investigator then asked P26, was the person who took the call, was the redacted third party? And the answer he received was yes. So I repeat my submission with even more emphasis: pure, unadulterated, and undiluted hearsay. What Mr. Nichols' rebuttal boils down to, maybe he didn't mean to infer it, but he did, all it boils down to is a plea that, well, Kaufman's pointed out a few problems, let's just leave it for the trial judges to sort out. And for that, he's quite happy to let Mr. Duterte fester in detention for years to come. In the United States, they call that kicking the can down the road. And as for the learned victims representative, I've been restrained up until now. I have paid my respect to the families of those who have lost loved ones, and I repeat that expression of sympathy that I made as my very first statement on behalf of the defense. But I would like to remind the learned representative for the victims that he is not a mini prosecutor, and to regale the pre-trial chamber with unsupported allegations that many, many children lost their lives is utterly inappropriate. His stance and that of his colleague have reflected the media reporting of this case, namely complete disregard of the evidence, and to be frank, you haven't heard one single piece of evidence cited by them. That's why they have Ms. Massiter sitting next to them. Indeed, the media interest in this case has been intense, but it has followed a familiar theme. Rodrigo Duterte is finally behind bars where he belongs. And as a defense lawyer, I stand up and I talk about due process, fair trial rights, and the presumption of innocence. But what use is that when the whole world has already tried and convicted him, and furthermore, make emotional arguments to justify their position? What about the presumption of innocence? Mr. Butuyan talks about threats emanating from mini Dutertes. He says that people are threatened by Duterte clones in countries all around the world. He tells you about Rodrigo Duterte converting millions of peace-loving citizens into bloodthirsty disciples. Not dozens, not hundreds, but millions, so Mr. Butuyan says. What an insult to the Filipino nation. And Mr. Butuyan concludes by presenting an emotional ultimatum. Confirm or Duterte will be portrayed as the person who vanquished the ICC. Those were his words. These submissions were quite unique for this court, and of course, totally irrelevant for the purpose for which we are gathered here today. And as for the mainstream media, back in the Philippines, the situation is not much better. When I argued that there has been interference in this case at the highest level, relying not on documentation that I have invented, but on documentation given to me by the prosecution as exonerating, they say I'm making a political speech and that my defense lacks substance. And when I devote more time than the prosecution and the victims together to legal arguments and challenging the evidence, they say I'm nitpicking. Well, fortunately, we have this honourable bench which appreciates the presumption of innocence and the need to examine the evidence thoroughly in order to examine whether the prosecution has proved its case to the required standard. We are fortunate in that we have this honourable bench to review the various arguments dispassionately and professionally. And we know that this honourable bench, despite our struggling with the various redactions that have considerably reduced our ability to make comprehensive submissions in open session, we know that this bench will assess our arguments faithfully. We have provided a comprehensive analysis of both the law and the charged incidents. We have attacked every single count in open session while doing our very best to respect the restrictions imposed upon us and applied by the prosecution to its charging document and pre-confirmation brief. And these redactions have not just been a few here and there, they have been so sweeping that virtually nothing intelligible remains of the 49 incidents that we have been talking about for the public to read and to understand, let me just screen you an example from the public record, from the public version of the pre-confirmation brief, so that the whole world can appreciate it. And the same goes for the redactions applied to the identities and roles of the various criminal cooperating participants. While I found this unfair and contrary to the spirit of transparency, which is meant to govern the conduct of the proceedings at this institution, I approached my counterpart in the prosecution and complained that the nature of his redactions would mean that most of my meaningful submissions, namely the attack on the evidence substantiating the 78 deaths, would require me to go into closed session. Don't worry, I was told by the learned prosecutor. We're going to release a lesser redacted version of our charging document and confirmation brief. Wonderful, I said to myself. But what in due course did we get? A document which merely released the names of the 8 so-called co-perpetrators and which caused a storm in the Philippines. It even caused the Secretary of the Interior to state that his department had begun tracing the whereabouts of these so-called co-perpetrators. And in its lesser redacted version of the document containing the charges and pre-confirmation brief, the prosecution also released the names of certain high-profile victims which it had selected, thereby enabling it, and it alone, to talk freely in open session about certain incidents that it felt crucial to its case. From this, I submit, Your Honours, you can really appreciate the true inequality of arms facing the defence as it attempts to defend a client in the public eye, I stress in the public eye, at the International Criminal Court. This inequality of arms in the public eye expresses itself in the way the prosecution controls the narrative by arbitrarily lifting redactions so that it can make its narrative of a grand scheme of co-perpetration known to the public in open court, while the defence can only meaningfully attack the real meat and the substance of the charges either obliquely or in closed session, including that hotly disputed incident with the CCTV. Well, we hope that we have found a way around that by referring Your Honours to the relevant places in the evidence, and we do trust you to pick up on the problems without the benefit of our full explanations in open session, even if the remaining part of our plea was rendered rather dry. But I do assure you, the general weaknesses that we have identified pervade throughout and are so recurring that the total value of the prosecution's evidentiary matrix drops not just below the substantial grounds threshold that the prosecution must meet, but hits the very rock-hard bottom. And I will summarize these weaknesses once more for the record. Layered hearsay, conjecture, over-reliance on accomplice evidence with offers of virtual immunity at the ICC, contradicting statements between participants in a crime, absolute lack of any linkage whatsoever to Mr. Rodrigo Duterte, and the total lack of support for an alleged crime both in the documentary and forensic record. And regarding these documents, it is not enough to argue that the Duterte administration destroyed them. There is absolutely no evidence for that. It is an outrageously unsubstantiated accusation which is not alleged, and where the documentation does exist, the prosecution is quite happy to rely on it. But what is this threshold, this substantial grounds to believe threshold? Well, clearly, it is not beyond a reasonable doubt. That's the standard required for a conviction at trial. But it is considerably more than reasonable grounds to believe, which is the standard applied for the issuance of an arrest warrant. If I may, let us take the analogy introduced by Mr. Butuyan, that boat of his that set sail in order to avoid leaving his victims stranded on an island. Your Honours, this boat is the confirmation process, and its captain is this honourable bench. We are all passengers in this boat. The favourable winds in the sea and in the sails are for the prosecution, the incriminating evidence, and the sharks and the rocks in shallow waters are the exonerating evidence, the hearsay, the contradictions, and the accomplice witnesses. I ask you to consider how many sharks and rocks that we have discovered and pointed out to you through our binoculars. Would you board that boat if you knew that there were substantial grounds to believe that the boat would sink if it encountered one of the aforementioned perils? Let me define the test using more strictly legal language. The evidentiary standard applicable, namely substantial grounds to believe, is met with respect to a discrete incident when, and I quote from paragraph 38 of the Said confirmation decision, there exists concrete and tangible proof demonstrating a clear line of reasoning underpinning the specific allegations. By way of parenthesis, I should state that this quote from the Said confirmation decision recognizes the fact that each pleaded incident in a document containing the charges must be proved to the requisite standard for it to be adduced at trial. And that is what we request the Honourable Pretrial Chamber to consider. I have been asked by the many journalists who literally mobbed me outside this court building whether I have been reporting on the proceedings to the former president. And I tell them, yes, of course, that's my duty as a lawyer. I have to report to my client. It would be unethical otherwise. And they ask me, what has he to say about the case? Well, I'm going to enlighten you all a bit. For the best part of a year, we have been litigating the issue of jurisdiction and fitness. Your Honours have delivered your rulings. However, even though you found him capable of standing trial, I permit myself to tell you just a little bit about what really goes on in prison. No more than a kilometre from here. I permit myself first to tell you about his reaction to the demand of the prosecution and the victims that he appear. I won't hide the fact that I thought it best for him to appear, not out of a need to satisfy the desire of the prosecutor and the victims who desperately want him to face his accusers so that they can wave their collected finger at him despite the presumption of innocence. I did not want to disappoint his many supporters. That was my reasoning. His mini Duterte clones, as Mr. Butuyan derisively calls them, who have been deprived of seeing their former and beloved president for more than a year. I told him that Your Honours could have rejected his request to waive the right of attendance. We even had a barong specially fitted for him so that he would not have to suffer the humiliation of being put into an out-of-size blue suit which would now dwarf his meagre physical body. The same blue suit in that dreadful photograph which still remains on the ICC website and that I would ask to be removed. But he took his decision, and as his counsel, I was obliged to respect it. And the day before yesterday, when Your Honours gave us a break, I went to that prison, and I sat with him for an hour. I tried to engage him concerning the evidence, and he lost the desire to follow me within less than a minute. I offered to show him excerpts of the confirmation proceedings, a few minutes of the deputy prosecutor, a few moments of Ms. Massiter, and hoping that it might excite him a bit more, some of my own opening statement. He shook his head firmly. I implored him. I said, "Sir, look at what we are doing for you. We're doing our utmost to get you out of here." But once again, he politely declined. And I asked him why. I said to him, "Sir, don't you understand? They accuse you of murder. They say that you murdered thousands when you were the mayor and when you were ruling your country." And then he repeated the question that he has always asked me for a year or more. "How does the prosecution say that I did this?" "Well," I replied, "I thought until Monday that it was because of those speeches of yours. But then your prosecutor told the honourable judges the other day, throw them all out. They're not necessary for the confirmation. He claims that he still has enough evidence to convict you without all the bluster." And the former president repeated the question, "But how?" I've never murdered anyone. And they talk about thousands. And then I try to explain to him arcane concepts such as indirect co-perpetration. And then his eyes simply glazed over. And who can blame him? As I mentioned, it is the only highly technical means whereby the prosecution can artificially connect him to criminal activity not of his own doing. I then tell him that the people who are incriminating him are self-confessed murderers cooperating with the prosecution, whose names we can't mention in public. I tell him that in return for their dubious services and their expressions of so-called remorse, as the prosecutor puts it, they will not face trial at the ICC, probably nowhere in the world, and will be rehoused with new identities. Mr. Duterte, the ex-prosecutor, like me, can't understand the fairness of that, relying on not one, but a number of vicious criminals to convict him, when he remembers that he is supposed to be presumed innocent. I tell him the names of those criminal cooperating witnesses, because apart from us, he is the only person who is entitled to know. He tells me that he has not heard of any of them, apart from two, who he vaguely recalls from his days as mayor. Concerning one, his comment is liar, and concerning the other, scallywag. And then, exactly in the spirit of the waiver filed with this court, he looked at me solemnly and said, Mr. Kaufman, Nick, I have done my duty and I have left my legacy. Go to court and do your job, but I can no longer help you. I no longer remember much at all, and I can't comment on people who I do not know and on statistics that mean nothing to me. He then concluded and pronounced as follows, I was a faithful servant of the people, and that is how I wish to be remembered. I have now accepted my fate, and I realized that I could die in prison. And on that somber note, my team and I realized that there was no point in continuing. So we tried to humor him. We told him that next month he will be 81. And we reminded him of the many people who visit Duterte Street and Duterte Park, the renamed locality just outside the ICC detention center, as referred to by the many, many pilgrims who have visited The Hague to feel closeness to his presence, even if they cannot witness his actual person with their own eyes. We remind him of the mountain of cards and greetings and of the forest of flowers that he received both at the detention center and at the court's premises on his 80th birthday. So many cards, all of which were read by his family, that we had to provide 2 sacks to take them back to our office. So many bouquets of flowers that the prison had to bring a van to take them away. The flowers that reached the court premises were strategically placed around the building, and although so appealing and desirable and coveted by the staff, were avoided once the staff was told of their origin. So these flowers just rotted in the corridors until the smell forced them to be thrown away. We showed him some photographs of his family. We showed him photographs of his youngest daughter, Veronica, Kitty, who writes to him every day so often that the letters are piling up in his room. His face starts to light up. We showed him pictures of civic events in the Philippines with Sebastian Baste and Paulo Pulong present. He laughed and told us what he remembers of their days as young men in Davao. We showed him pictures of Inday Sara greeting the enthusiastic crowds of people in the Philippines, and then finally his face beamed with pride. Your Honours, it is so easy to choose as a target for prosecution a politician because of the way he presents his policies. If Rodrigo Duterte is to be faulted for anything, it is for his inappropriate choice of language. But he murdered no one. Out of that huge database of evidence on which the prosecution relies, I repeat that there is absolutely nothing to directly link Rodrigo Duterte to the 78 deaths alleged. That is why they rely on on a few selective and vociferous individuals in the Duterte administration, calling them co-perpetrators, just so it can artificially superimpose their fantasy common plan theory linking Rodrigo Duterte to the victims. Your Honours, I beg you to be guided by evidence, which must reach a minimal level of integrity. Be persuaded by your own innate sense of justice and by your own collective years of experience. But most importantly, be guided by coherent evidence and by common sense. I ask you, I beg you not to confirm any of the charges. I ask you to let Rodrigo Duterte return to the Philippines, not to govern, but simply to let him live out the rest of his days in peace in his humble dwelling in Davao. And with that, Your Honours, I conclude, and I wish to thank you for your patience and to thank the parties and the participants, and most importantly, my team, Dov Jacobs, Avneet Nikisetti, Sandrine Dosena, Davide Rancati, Alexandra Dezev Davi, Nicholas Russo, and Kaylin Chen, all of whom have worked throughout the last year for one cause alone, and that is to serve our client, Mr. Rodrigo Duterte, faithfully.
Merci beaucoup.
George Motok. Thank you very much, Mr. Kaufman. The Chamber, my colleagues and myself, we have the duty to recall certain issues. First of all, the reductions that you have mentioned now, it was already raised by the defense, and the Chamber had taken a decision rejecting the position of the defense. The number of the decision is 388. And I should say that the quality of arms is ensured because the defense has access to the redacted information. It just is not available to the public. Secondly, you talked about the health and capacity of the suspect. As you have clarified, this issue was already addressed by the Chamber, and the defense must not make submissions on that point now because it is not appropriate. The decision is already available in the public domain. I thank you very much, and with that we come to the end of the confirmation of charges hearings. I thank the parties. Did you want the floor, Mr. Prosecutor?
For you, Your Honor. Yeah, thank you, Your Honor. I don't want to stand up and object to my friend, but I would request and ask that you strike and not take any account of any word that my friend said came from his client. None of that was responsive to arguments, which is what these last 30 minutes were about. You made that clear on pages 24 and 25 of the transcript today, and it's in paragraph 9 of your order on the conduct of the hearings. Second of all, my friend can't testify for his client or make a speech for his client. That's governed by Article 67H. If he wanted to come here, he didn't want to come here, he could have come here and talked about whatever he wanted to, but he chose not to. Mr. Kaufman's conveying this. He's been complaining about hearsay all day. It's not reliable, but beyond that, if Mr. Duterte wants to speak to the court and speak to the gallery, he should come here, request to make an unsworn statement. He shouldn't do that through his counsel. So I ask that all of that be given zero weight whatsoever in your determinations. Thank you.
Thank you, Mr. Prosecutor. You want the floor again, Mr. Kaufman?
Madam President, but I do believe that the defense has the right to respond.
Wait.
Yes, says Judge Moto.
And I say to Mr. Nichols that this was not testimony. It was purely an explanation for him not coming to the hearing. He has the maximum respect, obviously, for your honours, but he has his arguments, which we shan't repeat here once again. They were all set out in the waiver. That was not testimony, I assure you, Mr. Nichols.
Merci.
Judge Moto, thank you very much. Now the bench will withdraw to deliberate and we will render a decision on the confirmation of hearings within 60 days in accordance with the instruments, the provisions. We will come back to this court for a hearing on Mr. Duterte's detention. Court is suspended.
Ayan mga kabombo at mga Kastar Nation, yung naging takbo ng confirmation of charges hearing at nasa kanina ay sumalang itong si Nicholas Kaufman at ipinaliwanag ko niya yung hindi na pagkakaroon ng interes ni former President Rodrigo Duterte na mag-appear pa ng personal dyan sa pre-trial chamber 1. At yan ay kaugnay doon sa kanyang kalusugan at sa kanyang kondisyon. Yung paliwanag pa ni Kaufman ay sinubukan niya na ilahad ang mga nangyari sa confirmation of charges hearing, ngunit agad na hong inaamin nitong si former President Rodrigo Duterte na hindi niya na ma-absorb yung ilan mga impormasyon hinggil ho doon sa takbo ng kaso na kanyang kinakaharap mga kabombo at mga Kastar Nation. So yan yung naging takbo ho ng confirmation of charges hearing, and the court is suspended di kanila at magbabalik sa korte pagkalipas ho ng 60 araw. So after 2 months mga kabombo at mga Kastar Nation. So yan na ho yung paglalagom dito sa proceedings at unless may mga pahabol na anunsyo sa panig ho ng mga huwes na siyang umaakto dito sa International Criminal Court bilang pre-trial chamber o itong para sa confirmation of charges na isinagawa sa magkakasunod ho ng mga araw maliban sa nitong Miyerkules mga kabombo at mga Kastar Nation. So tutok pala pa rin mga kabombo, mga Kastar Nation sa mga karagdagang update at syempre yung ating mga recap ng mga kaganapan dyan pa rin sa International Criminal Court. And bukas ay muli ho nating susubukan na makausap yung mga personalidad na personal na nagtungo doon para naman sila mismo yung makapagkwento kung anong naging takbo ng kabuuan ng itong confirmation of charges hearing. Lalo't hindi naman ho ito ibinahagi ng buo ng International Criminal Court. No? May mga bahagi na redacted, ikanila ay hindi na ho isinapubliko dahil dun sa pagiging maselan ng mga paksa na pinag-uusapan mga kabombo at mga Kastar Nation. So yan mga kabombo, ang atin hong naging pagtugay guys sa kabuuan ng confirmation of charges hearing dito ho sa International Criminal Court. Antabay mga kabombo at mga Kastar Nation sa mga darating pang araw kaugnay ng mga kaganapan ho na ito mga kabombo at muli ho ay ihahatid namin ang mga anumang mga development hinggil ho dyan sa kabuuan ng ating mga pagbabalita. At mula rito sa Bombo News Center, Makati, this is Bombo Radio Philippines, the #1 and most trusted source of news and information. Basta Radio, Bombo!
For the most trusted source of news and information, visit our website at www.bomboradio.com. Follow us on Bombo Radio mobile app, Facebook, YouTube, TikTok, and X, formerly Twitter. Like, share, and stay connected. Anytime, anywhere.